Good morning to all. Before starting, I would like to remind you that there's a translation available and you just have to click. Good morning, everyone. In the name of Colombia Freedom of Expression, I'm happy to welcome you for the second webinar on the French version of the My name is Anderson Javier Diaz de Leon, and I am a lawyer specialized in human rights, and I work for Colombia Freedom of Expression, and I am proud to launch this webinar in collaboration with Article Negan. This is the second webinar out of 4 that we are going to have. You can consult the agenda on our website. And I would like to use this occasion to invite you to make an evaluation. Columbia Freedom of Expression is an initiative of the Columbia University, started by the university's president to promote the judicial protection of freedom of expression and freedom of press worldwide. Our project is based on the universal jurisprudence. We have examined over 2,000 cases worldwide in the jurisprudence of freedom of expression in the Inter-American Human Rights Court and the European Court. The French version has already more than 5 years and it responds to a lot of questions related to the freedom of expression. Also, new cases are added each month. We have documents regarding international freedom of expression rights, hate speech, the right to be forgotten, and all other cases in the Inter-American, African, and European courts. These decisions give us a global perspective of the freedom of expression's rights adopted in the national and international courts in freedom of expression. The database in French is made possible thanks to UNESCO's program on freedom of expression and protection of journalists. And the University of Nairobi, Kenya. And we thank them for their support. This webinar is going to last 1 hour. It's going to be published and our participants are going to be uploaded in the Columbia Freedom of Expression website. And we are going to leave time at the end so participants can make questions and comments. In order to doing that, please use the chat here on Zoom and also on YouTube. Please welcome Mr. Basil Adder, who is going to be the moderator. Thank you very much, dear colleagues, for participating in this course, which is very important for freedom of expression, which is the right to be forgotten. We're going to have 2 speakers who are going to explain the rights applicable in their countries. We're going to have Ramiro Alvarez Ugarte, who is the Director of Freedom of Expression and Access of Information in Argentina. And he makes jurisprudential work on the right to be forgotten on the internet. He's going to have the word for 12 minutes, and then we're going to have Frederick Grass, who collaborates in a journal in which I am the director, and he's a specialist on the right to be forgotten. I give them the word, and the rest is to you.
Thank you, Basile. It's a pleasure to be here. I'm really close to the project for a bunch of reasons. I'm close to Colombia because I studied there, my master's degree and my doctoral degree. And I have been part of the Global Freedom of Expression projects for a long time now. I was very happy when Catalina asked me a couple of years ago to coordinate a few webinars on the issue of violence against journalists. And I also was happy to work on the paper that I will discuss today. The right to be forgotten is a very important and actually relevant issue in freedom of expression jurisprudence around the world. At CELE, which is where I work, a research center based in Buenos Aires, we have studied this for a long time. One of the most important precedents in Latin America comes from the Argentina Supreme Court. The paper that I will discuss is actually a good example of the kind of use that the Global Freedom of Expression database can be put to, because it is truly global in a scope and reach. When I was given the task to review the work of colleagues who have basically went through the database in order to gather all the relevant case law, I was surprised to see how many cases about the right to be forgotten existed there. So my work there was try to make sense of all the information and try to put it in context and to understand where this issue comes from, where it's going, and what are the risks, I would say, implied in strong recognition of a right to be forgotten for freedom of expression purposes. The first thing I would say in this regard is that clearly the right to be forgotten is something that comes out of the internet. It is a true internet child. The right to be forgotten emerges in the context of the internet as a technology that changes the way we access information and that produces new sets of problems and issues. In this case, it has to do with the issue of permanence of information on the internet and easy access to the internet. This is a new problem. We have actually an open call for papers at CELE in which we try to address some of these issues, the issue of speed, scope, virality, and the issue of permanence is certainly one of the new things that comes with the internet. Before the internet, information would stay in books, in newspapers, but accessing them was difficult. They would be hidden in the stacks of old libraries full of dust. This is no longer the case. When we produce information and we upload it to the internet, the information somehow acquires a feature, which is it becomes permanent. It becomes, in a way, forever. And we were not, as humans, we were not used to that. So this is new. It's a new problem. And what we've seen around the world, especially after the Costeja decision, which is, of course, the leading case on the right to be forgotten, is that two general approaches has been developing at the same time. One of them makes a strong claim about the right to be forgotten, which is somewhat strange because we don't have a right to be forgotten in our social world. We might be remembered if we do good or bad things. We might be forgotten if we do the same, but we have never spoken until now of a right to be forgotten. You would like to be forgotten if you did something wrong. And I guess if you did something right, you would like to be remembered. But we never spoke about being forgotten or being remembered as implying a right. So in a way, it's a strange form of talking about the harm that is produced by the permanence of information on the internet. The other approach is, I would say, narrower, and it has to do with de-indexation as an appropriate remedy for certain harms. This approach, in a way, it makes a less or a weaker claim, and it speaks in terms of procedure, and it speaks in terms of remedies to certain harms, which I think it's a better approach. In any case, when we talk about the right to be forgotten, we're usually talking about the indexation, but there are differences between both approaches, especially in terms of how strongly we talk about this issue. And I believe these differences are important. What the report has done is to take the Global Freedom of Expression database and analyze all the cases that has been documented in the database about the so-called right to be forgotten. I would say that the paper identifies a few challenges in terms of how the right to be forgotten is recognized by courts around the world. The first thing that I would say is that, generally speaking, the right to be forgotten, as recognized by courts around the world, has a weak statutory background. So generally speaking, legislatures around the world, which are the ones that produce the laws that govern our lives in our communities, have not really passed right to be forgotten laws. This right has emerged, as I said before, as a remedy to a special kind of harm. It is a court-produced right or court-recognized right. And this is problematic from a freedom of expression standpoint, because in most international human rights systems, the first step to assess the legitimacy of a restriction of freedom of expression establishes that that restrictions must be established by law in a material and formal sense. So this is a first challenge. One of the ways in which this challenge has been addressed is that many courts around, not all courts around the world, but many courts that has embraced or considered freedom of the right to be forgotten, have grounded these rights on data protection schemes. It has considered the information involved in a right to be forgotten claim as involving a claim about the right to control personal data or the right to privacy, but generally as through the procedural tools included in data protection laws. And this is somewhat problematic. It is not the best fit to use data protection laws for grounding this kind of right, or as I prefer to consider, this kind of remedy, because data protection laws generally have not been drafted or produced to deal with these issues. Data protection laws has been produced to deal with other interests, which has to do with other issues. And generally, because of that reason, data protection laws and regimes do not include any structured pattern of consideration of the freedom of expression interest involved. And this is a problem. But because it comes from courts and not from legislatures, courts have found this shortcut of grounding these remedies into data protection laws. There is another problem that I see in the trend that the paper discusses, which is that because it hasn't been regulated, it has encouraged a kind of litigation that looks a lot like SLAPS, strategic litigation against public participation. Not in all cases, of course, Costeja being the case in which there seems to be a legitimate claim on the right to be forgotten, but in a lot of other areas and countries, I have studied this particularly in Argentina and to an extent in Colombia, we have seen the invocation of the right to be forgotten in a way that is really similar to SLAPS, in which the purpose seems to be not so much actually taking down information, but rather creating through litigation a kind of pressure on media outlets, which is another, the third challenge that I would mention. This usage is a threat to freedom of the press, which media companies, newspapers, and so on are often the main defendants in right to be forgotten cases. And the other thing that I would mention is that in some cases that are discussed in the paper, we see a very important analysis, which is considering and which is the following: courts should consider the availability of less restrictive remedies than a strong right to be forgotten claims or strong de-indexation. It is easy to imagine how other remedies could have less restrictive effects on freedom of expression. All these challenges come from a very broad and general take on the case law. We see different trends. So for instance, in Latin America, courts have been mostly not very friendly to right to be forgotten claims. There are a lot of reasons for that. Some authors have pointed out towards past human rights abuses and the development of a juridical idea of memory and the right to truth as one reason why Latin American courts have been really unfriendly to right to be forgotten claims. We see more friendliness towards right to be forgotten in Europe, but this is not total. We see different trends within Europe as well. We see more friendliness towards right to be forgotten claims in Asia. So there are different trends around the world, but we can also see some degree of cross-pollination between courts, in which some precedents are really taking as very important in other jurisdictions. Costeja is, of course, the main case, but we have seen some degree of cross-pollination of right to be forgotten cases in Latin America, in which courts from different countries cite each other, which is, we believe, an interesting development. Under the right to be forgotten, I would say we have, besides the challenges that I have already mentioned, because of its emergence, I see that we have three features that are important from the point of view of freedom of expression law around the world. One of them is that the right to be forgotten has contributed to weaken the strong non-liability rules that control the intermediary companies on the internet since the 2000s until now. So it's not the only reason why this rule has been weakened across with the passing of time, but it is one of the reasons. The other concern in right to be forgotten claims that has been taken up by some courts is the need to include publishers, which is very important when the issues being involved are of the public interest and include as defendants newspapers and media companies. And the other thing that it's clear is that we see in the right to be forgotten claims a new, I would say, a new battle in the jurisdictional wars of the internet. So this that has happened for a long time happens again with the right to be forgotten. I will close with the following, which is The privacy claims involved in the right to be forgotten are, of course, very important. But we have seen some cases that the paper discusses in which there has been a really good balancing exercise between privacy claims and freedom of expression claims. This needs to be balanced, of course, in a case on a case-by-case basis. This is what most constitutional law around the world recommends, what human rights law standards around the world call for. And some cases have been very good at doing this. Some courts have been very good at doing this. The reputation and honor involved in right to be forgotten claims has also been discussed properly by some courts. The Biancardi case in Europe is perhaps one of the best examples of this approach. And the main problem that we see, and I think it is where courts should strive to strike the right balance and generally against right to be forgotten claims, is when public figures are involved or when the issue being discussed is of the public interest. This is, I would say, the riskier scenario from a freedom of expression point of view of right to be forgotten claims. And this is where right to be forgotten claims and the indexation as a remedy generally should be narrower and more restrictive. The alternative measures discussed before, such as the possibility of annotating the original information, such as unlinking certain names from certain pieces of information. This should also be considered in the context of adjudicating these kinds of controversies. And this is, I think, where this global case law is moving and is going. This is, of course, a prediction. It is only based on what we see until now. This paper has at least a year old, so I'm sure there are new cases around. I think they Holly from Global Freedom of Expression has just sent me last week new cases that have been included in the database and are not in the website in the paper, but I have seen them generally, and I think this is where it's going, to narrower right to be forgotten claims, to narrower the indexation measures and alternative measures, and to striking the right balance between competing claims, which is what lies behind right to be forgotten case. Thank you very much.
Merci, Basile. Ce que l'on peut dire en ce qui concerne l'anonymisation des décisions de justice, c'est que le principe de publicité de la justice et le principe d'exemplarité de la peine a toujours été prévalent en droit, en tout cas en droit français. Et à ce point que dans une décision de la Cour d'appel de Paris de 2014, il était dit, je cite, « Le droit à l'oubli n'a aucune reconnaissance légale et ne saurait prévaloir sur le droit du public à l'information exhaustive et objective. » Et on retrouve un tel principe également dans un arrêt de la Cour européenne des droits de l'homme du 28 juin 2018, où il a été considéré qu'il n'y avait pas lieu d'anonymiser des articles qui
Considered that there was
étaient
not a right of anonymization.
précisément parce que
Precisely because judges unanimously considered that the press was not considered by that measure. So the solution was not to be, according to the European Court of Human Rights, we had 12 judges against 5. And 5 decided that there was a right to be forgotten, and 12 decided that there was not in this accident. Sure. But what are the causes of the anonymization of the judicial decisions in France? What is the practice? Concerning to the cause is, for starters, the doctrine that is reinforced by the National Commission of the Freedom of Expression, which is very particular, which since the 1990s has considered that the database in jurisprudence should be examined document by document. So the database, the judicial database, should not be examined by lawyers. If it is examined only by lawyers and not by the public, then they should not have a problem with the personal database being available for the lawyers. But after the jurisprudence was made available to the public, that's where the question started, that was it necessary to have a right to be forgotten? And an anonymization of the parts, anonymization of the witnesses, and not anonymization for the judge, because we consider that the judge should appear on the decision and take the responsibility for the decision. But that commission decided on the law of October 7, 2016, that the publicitation of justice was included in the right of privacy. So cases should be numbered and not have the names of the parties in order to protect the right to privacy. That's the first part. And then in March 2019, there was a new article added to that law, Article 16, which says that the name and surname of the persons in the cases, all the parts, should be deleted. And also the name of the judges, the name of the witnesses, and the names of all the parties, to protect the rights of privacy and the protection of their environment. But there was a case presented in which they wanted to bring the names of the judges and the names of the parts in order to make it searchable. Then in 2022, there was a case regarding the application of the 2019 law, and this case claimed that the Article 16 on the European Commission didn't protect fully the name and surnames of people. They decided that according to the European Commission, the publicity of the decisions, the publicity of the claims should be available to the public, but not the names and the distinguishable feats of the parties. So another article was added to the law, complementary, regarding how intelligible was the decisions taken in justice. Which claimed that decisions were hard to understand if the parts were anonymized. Which brings us a lot of questions. The first question is, is justice brought about in the name of the people of France? If it is brought about in the name of the people of France, then all the people of France have the right to have access to the names of the parties and all the facts. All that publicity should be made available to the public if justice is served in the name of the people of France. The second question is if justice is just the decisions that are taken or all the private lives and the private implications that cases have. And thirdly, the question was if the right of privacy was more important than the right of justice and the right of people to access the justice decisions. So there was a need of making a balance to decide which of the rights was more important. As we can imagine, certain parties wanted to have their names associated to the justice decisions. But the decision was that the right of privacy is not an absolute right. It has to have a conciliation with the general interest, the right to information, which was decided by the European Court, the French Supreme Court, and other courts in France, which have considered that the disposition of the facts to the press should be available. The Constitutional Council decided 10 years ago that the press did have a right to access the facts and the names. But the 15th article of the European Charter of Human Rights says that journalists don't have a personal right to access to information. They don't have a right to personal facts, to names, addresses, and all the facts regarding a person. That is not covered by the right to information. That's why the National Commission of Freedom of Expression decided that they did not have a right to access the names. So they did have a right to access the facts, but not the names. But what that brings as problems is that, first of all, the anonymization is made by a software, and that implies IA, which sometimes is risky. If you have an artificial intelligence deciding on human rights, that can be tricky. In 2023, we had a case of a politician that was involved in a case, and his name was anonymized, but also the software also anonymized all the names of the parties involved, but also the names of the quotes that he had, the names of the parties not involved, and all the arguments that he made were then weakened because it was anonymized by a software that could not decide which were the parts and which are the arguments. So this decision by the Supreme Court anonymized not only the names of the parties, but basically avoided the decision of the most important things that that regarded quotes and made it unintelligible. It was hard to understand what they were arguing with all this anonymization made by the artificial intelligence. So this is an exemplary of how the covering of one right can also break some other rights. But in the context of the media, we can think of the right to social security. We think that the right to social protection also has a right of privacy. So in other cases regarding social security, the names of the parties were deleted, but also the names of the societies that were part of the case and the names of the agencies of government that were involved in the case. So we have made anonymous not only the names of the parties, but also the names of the institutions. And this vocation of being anonymized, what does it cover? Does it cover only the persons, or does it also cover the institutions? So the court decided that it was not, that the goal of this right to privacy was to protect persons and not to protect the institutions and not to protect the government and not to protect the agencies. So when you delete everything and you anonymize every one of the parts, you can also anonymize and delete what was the actual case that was brought about, because it is hard to understand. So the door that we have opened to anonymization is a very big door. And that presents us with the new risks of not having the judicial registrations or accessibility to the decisions in justice. So this is a criticism that is really important. So university teachers have claimed, university teachers have claimed one time after the other that it is only a right that should pertain people and not institutions. So the anonymization of decisions is giving an appearance of general character because the person disappears, the parts disappear, and this general character is not in the nature of the judicial decision. If there is a judicial decision, the right to information should cover the right to knowing what actually happened, which is what was decided on July 23rd, 2023. Which says that decisions should not be generalized. Decisions should be brought to the public in their context. So the right of information should cover the right of having the facts and also the names of the parties. So they decided that anonymizing the judicial decisions, one protects the right to privacy, yes, but one brings confusion between which were the parties involved, what was the goal, and what is the right protected. If the parties are not clearly stated, be it persons or institutions, then the people who are studying the cases cannot understand what is the right and how does that apply to them in an eventual case. That's all I have to say. Thank you very much, Mr. Grass, for speaking about the right of anonymization and the right to be forgotten in French. Which is not only pertaining the right to be forgotten, but also if you do have a right to have some histories attached to your name. That's a question that we should ask ourselves. Do the people listening have some questions to make to our speakers? Does someone between you has a question? You can raise your hand. I think they can. So I'm going to make the first question to Mr. Alvarez Ugarte. Does the jurisdiction, the Latin American jurisdiction in Spanish or in Argentina, do you have strict rules on the anonymization of judiciary decisions? Do you have the same problems in Spain or Argentina?
Thank you, Basil. We, to the best of my knowledge, in Latin America generally, the anonymization of judicial information is very restrictive. It's very restricted to only a few sets of cases. Cases involving family law, in which there are children involved in the cases. There are some cases in which the information on victims of certain crimes is anonymized. But besides family law and criminal law, and criminal law also in a few sets of cases, the anonymization is not a extended policy. Sometimes the anonymization is done manually; it's not done automatically or anything of the sort. And usually the letters of the names are used, which is very bad for actually hiding the information of the person involved. I remember a very famous case on actually freedom of expression from a few years ago, in which the name of the case was M,D,A, which was a case involving Diego Maradona because of a paternal demand by someone. So that's the kind of the anonymization I have seen in Latin America, but this is probably one of the reasons that may explain this limitation or narrowness of the policy, is that most decisions are printed in PDFs. So it's like the actual paper version of the decision is what it's being uploaded to a database. So that makes gathering the information and processing it very difficult, and that may explain why there hasn't been a strong demand to de-anonymize information, because it cannot really be processed automatically as you can do with plain text databases.
Merci beaucoup. Frédéric Gras, qu'est-ce que vous pouvez dire
Thank
sur
you very much, Frederick Grass. What can you tell us about?
Sur
about the position of the jurisprudence in the European community the European Court has tried to take one decision to has the European Court made a decision to unify the criteria, or is it just for the famous people, or can everyone reclaim the right to be forgotten? There are two tendencies. There's a tendency that says that indexations, that there is a possibility of indexations, and we talk about indexation, but we don't talk about the anonymization in the beginning of the process. And I think that that's important, because that says that we touch what comes to the library, but we don't touch the library. So we don't touch the database. It's exactly, we touch a part of the library. They say that we delete the board, but we say that on the library, you can find the information. That's the solution that the European Court found on this indexation question, with some dissident opinions and concordant opinions that bring clarity to this decision. The decision was that you should see case by case, that you can anonymize one article published by the press under the pretext that the person who was cited was a doctor, and that could limit the exercise of his activity as a doctor to see his name associated to a case that came. And on this particular case, since it was a case-by-case decision, on this case, the European Court decided that they could anonymize this decision. We don't delete the whole thing, but one puts XXXX on the name of the person. But the funny part is that the only parts that don't have the right to be anonymized are the lawyers. But you can see that when lawyers are in decisions that are not flattering for their part, they do not want to be involved in that decision. They would like to be anonymized. And one would like to say that they also have the right to be forgotten. Yes, because we put the names of the lawyers, but not the names of the parts. But what you do know is the lawyer who lost that case. Yes, in some decisions, one anonymized the place where the society is placed, the institution is placed, but one doesn't delete the name of the lawyer. So through the lawyer, you can also find where this agency or this institution is located. Finding the lawyer, you can find the place where the decision was taken. But this is an anonymization that is automized by a system and the software. So that's not necessarily satisfactory in anonymizing all the identifiable parts. Are there any more questions? I don't see anything in the chat. I see people talking, but not questions. I would like to ask Ramiro Alvarez Ugarte if today the right to be forgotten is a little bit on the justiciable part. Is it a natural right, like the right to privacy, the right to a private life? is that a natural right, or people have to ask for the anonymization of the cases case by case?
This is a very good and important question. I think the short answer is I don't know. I guess it also depends on what theory of rights we embrace. But what I would say is that from a descriptive point of view is that this right has really emerged in claims and demands made by people who have felt that they were harmed by something that happens in the world that has to do with the permanence of the information on the internet. Most rights, if you see rights historically, they often come from demands made by people on the streets, in front of courts. But this is usually the way that rights get recognized. I think we are at that moment of creation in which the claims and demands appear. Some courts are friendly towards right to be forgotten claims. Some courts are less friendly. But I wouldn't be surprised if an autonomous right to be forgotten, which probably ends up being narrowed down to something about the right to have your information being de-indexed under certain circumstances, it will be recognized by most courts around the world. And I think this has to do simply with the fact that the world today is very different from the world 40 years ago, that the internet has changed things materially, and that this produces effects, and the law catches up to those effects. So my intuition is that is that the right to be forgotten or the right to de-indexation under certain circumstances will be increasingly recognized by courts and legislatures around the world as an autonomous right, that it's linked to privacy, that it's linked to data protection, but that it's separate from them.
It's separate, yes, I think so too. Et vous pensez que ça doit être l'œuvre du législateur, ou est-ce qu'il faut laisser...
Do you think that that has to be the work of the legislator, or
s'il doit être laissé à l'appréciation au cas par cas par les juges?
does it have to be appreciated case by case by the judges?
I believe legislators should step in and regulate the conditions under which the indexation should happen. In that sense, I believe that in Latin America, even though our constitutional law comes mainly, has been inspired by the United States, our law and our civil law has been inspired by French law. And so we believe in the supremacy of the legislature as the representative of the people. So I would say that yes, that the legislature should intervene. At the same time, because it is such a complex issue, the nuance that can be given to the issue by courts deciding case by case on a case by case basis, it would be very helpful for legislatures. So it would make sense to have a lot of case laws and the legislature learning about those cases
And then saying,
and
okay,
legislating afterwards.
Okay, I understand. Et il y a dans le droit français, en matière de données personnelles, hein, personal data,
So on personal data,
une exception dans la loi pour les informations de
do you
nature
have an exception on the
journalistique.
law regarding the informations of a journalistic regarding the journalistic information?
Donc, il y a une exception qui fait
exception
que les journaux peuvent donner le nom des
Make
gens
the media can actually give the names of the people
dès lors que c'est justifié par l'actualité. Est-ce que vous pensez qu'il devrait
Is
y
it
avoir,
justifiable by this
s'il y a
rights
une
of
loi
media?
sur le droit à l'oubli, une exception pour les
If
informations
there's a
journalistiques?
right to be forgotten in the law, do you think that it should have an exception for journalists and for journalistic information?
Yeah.
I would say so, yes. My intuition is that the indexation, when dealing with media companies, newspapers, and journalists generally, should be really limited to cases in which the information is no longer relevant and where the impact on the availability of the information is as minimum as possible. And this, I think, probably the way to get the answer that I believe intuitively that it's the best answer is to not start from the perspective of the journalist, but from the perspective of what kind of information is being discussed there. So if the information is of a public figure, of a politician, of a legislator, or someone who takes part in public debate, that information should be protected from right to be forgotten claims, especially if that person is a public figure. Whether the one who has published the information is someone blogging or an actual newspaper with its institutional backing. I believe getting into the issue through the kind of information being covered is better than getting into the issue through the point of view of journalists or newspapers and so on.
There's a kind of presumption. Yeah. As soon as it is a journalist, normally ça intéresse tout le monde. Je crois que c'est l'heure de conclure, Anderson. Si vous voulez, je vous redonne la parole pour donner un mot.
I think it is the time to conclude.
Je peux simplement dire que c'est quand même un droit nouveau et que vous avez
I would say that it is a new right and you have all the reason
de vous y intéresser parce que il va, à mon avis, continuer de s'affirmer et de se
I
préciser.
think that it is going to be refined and precise in the forthcoming
Donc bravo
years.
pour votre choix de sujet.
Bravo for your choice of subject. Thank you, Mr. Adair and Mr. Gra and Professor Alvarez-Ugarte for your participation and for the questions and the engagement. Please don't forget that the video on streaming is going to be published in Colombia Freedom of Expression in English and French. I invite you to take part in the next webinar on the 25th. And April the 4th, that we are going to talk on the African systems of human rights. We have on the Zoom chat shared the complete agenda. So I invite you to make all your contributions to the database or anything that you would like. That's welcome. Thank you for being here and see you later. It was a pleasure to have you.